That is what you are suggesting.
See,
reality बहुत different है. The reality is very different. We all know what is the reality.
निकालें आपका नंबर क्या है?
आप हाई कोर्ट्स की रिपोर्ट्स तो देखें. वो सारे जजेस हैं. ये वो गलत नहीं कह सकते. आप जिस तरह भून साहब ने कहा है उसको देख के हो सकता है आपका व्यू चेंज हो जाए.
जी, what number are you filed?
398, I've been told.
398.
CMA 398 of 2024.
ये जो अभी दी आपने?
जी मैंने आज ही दिया.
आपने तो हाई कोर्ट के देख लिए ना?
Do you want to read it or you want to?
But I'll be reading it out. But before that, may I very humbly request all the honorable judges here.
To interrupt you.
No, my lord, I am more than happy to have interruptions. What I'm requesting here is that when we say on live TV, which the whole nation is watching, that the Supreme Court was complicit, or for that matter that the judges were compromised, the Superior Court judges were compromised, we are not sending a good message. And these hearing, what happened in the last state of hearing is actually eroding public trust. And this trust
hearing is eroding public trust.
My lord, what was said in the hearing on the last day, and I'll be pointing it out when I read from
President Saab, who are we answerable to?
We are answerable to firstly to Almighty Allah, and then to any other.
Let him complete it. Please, otherwise we'll be hurting.
आपने कह दिया ना. देखें, President Saab, हमने 76 साल झूठ बोला है, सच को छुपाया है, जिससे हमारी credibility बिल्कुल erode है. People do not have confidence.
Sorry to say, I have to interrupt. Please proceed with your case.
So grateful, sir.
People must know the truth.
Yes, my lord.
Don't be afraid of that.
My lord, the truth should come from somewhere else. If you're sitting here and you're actually accepting that you were complicit,
then you have no business to sit here.
What is the answer?
Then why don't you say you have no business to sit here?
So let me first.
Sorry, I will put it very bluntly. If you are complicit, don't sit here.
Let me start. I'll read. Let's my lords, let's not enter into a debate.
It is not I that I have said it. It is the Attorney General who said it.
Everybody said it.
In the High Court,
Lord,
yes.
It is so recorded in the High Court's comments.
But in the High Court, there were judges.
Well, Lord, let me start from here. I very humbly draw my Lord's attention to para G at page 5 of the CMA. I'll read that first and then I'll start. It is deeply concerning to note that the judgment dated April 29, 2024 by a judge of the Islamabad High Court, which explicitly stated, and I quote, "The letter is not in the nature of a complaint, as the SGC has no mandate to investigate the actions of intelligence operatives, and was also not a communication meant for public consumption. It was a confidential intra-institutional correspondence that got leaked to the media and has attracted public debate." This was recently said by an honorable judge of the Islamabad High Court.
Who said it?
My Lord Justice Babu Sattar. I was not actually happy to name someone. It is surprising that this judge, a signatory to the said letter, claims it was meant to be confidential. An urgent inquiry is necessary to determine how the letter was publicized without first being addressed to the chairman and members of the Supreme Judicial Council. The individual responsible for its leakage must be identified and held accountable. Now, my Lord, I take your lordships back. I will start reading from para 5 of the CMA that I filed. The Constitution of Pakistan, I hope my lords are there.
Paragraph?
Para 5, page 2 of the CMA, sir. The Constitution of Pakistan entrusts the judiciary with the sacred duty of upholding justice free from external influences. This principle is fundamental not only to the administration of justice, but also to maintaining the balance of power within the state. It is imperative that judicial independence be safeguarded at all costs to ensure a just and equitable society. The Supreme Court Bar Association of Pakistan reiterates that any attempts by other branches of the government to undermine this independence are unconstitutional and detrimental to the rule of law. In the light of recent events, the Supreme Court Bar urges the Supreme Court to reassert its constitutional authority and to ensure that mechanisms are in place to prevent any form of coercion or undue influence from state agencies. The judiciary must operate without any direct or indirect pressure that could compromise its impartiality. This includes, but is not limited to, inappropriate communications, threats, or any other forms of interference in the due process of law and judicial decision making. Furthermore, the Supreme Court Bar advocates for the enactment of stricter laws and regulations that penalizes interferences in judicial matters. These should be designed to protect judges from pressure that can arise from other branches of the government or from within their own ranks. Ensuring that judges are able to perform their duties without fear of retribution is crucial for maintaining public confidence in the judicial system. In these circumstances, the Supreme Court Bar submits the following proposals. While the Supreme Court Bar welcomes the initiation of instant proceedings under Article 184(3) of the Constitution, however, it is suggested with utmost respect that the autonomy and independence of the High Court, as enunciated in the Constitution, must be kept in mind while deciding the instant list. It is also humbly submitted that the issue in hand has significantly eroded public trust towards the judiciary as the organ of the state. Any such incidents as the one highlighted in the letter dated 25th of March 2024 should ideally be addressed internally by this Honorable Court or by the High Court itself, as the High Court is constitutionally empowered to devise its own practice and procedures. The public exposure of the letter and the ensuing proceedings have severely affected the sanctity of the judiciary as an organ of the state in the eyes of the public. Being a judge is not merely a profession but a calling, necessitating a sacred commitment to ethics and duty. The old adage of being above suspicion, like Caesar's wife, underscores the necessity for impeccable personal conduct and professional integrity. The basic oath of a judge, as provided in the Constitution, mandates service without fear or favor, affection or ill will, a directive that must be followed both in letter and in spirit. Failure to do so constitutes a violation of the solemn oath sworn upon the Constitution, carrying significant consequences. The judiciary primarily comprises the constitutional judiciary, the Supreme Court and the High Courts, and the subordinate judiciary, which is subordinate to the respective High Courts. The practice and procedure relating to the judiciary are addressed in Articles 202 and 203 of the Constitution. The Code of Conduct, established by the Supreme Judicial Council under Article 2098 of the Constitution, serves as the primary guideline for judicial behavior of superior judge. Although encompassing this code should not be seen as conclusive, it sets the basic standards for a judge's conduct, emphasizing that the Constitution declares all authority exercisable by the people as a sacred trust from Almighty Allah, indicating that justice in this nation has a divine origin. This underscores the full implementation of high constitutional principles and the universal requirements of natural justice. A judge's oath signifies complete submission to the Constitution and, by extension, to the law. Within these bounds, his function of interpreting and applying the Constitution and the law is essential for maintaining the rule of law across all human activities within the nation. The letter dated 25th of March 2024, authored by 6 judges of the Islamabad High Court, should serve as an eye-opener. It provides a free untoward incidents in the future. This Honorable Court should note that Article 204 of the Constitution grants the powers of the contempt of court, further bolstered by the Contempt of Court Ordinance. This ordinance empowers every superior court to address contempts committed in relation to it. The incidents detailed in the letter dated 25th of March trace back to the previous year. It is crucial for a strong message to be sent to the Parliament and the executive and its institutions that no interference will be tolerated henceforth. An inquiry into these incidents should be conducted to determine what exactly transpired and why the approach judge of the High Court failed to act as provided under Article 204 of the Constitution, read with the Contempt of Court Ordinance 2003. It is particularly alarming that the 6 judges of the Islamabad High Court reported being approached and pressured without specifying the cases for the individuals involved. This situation necessitates consideration of why these judges were unable to issue contempt citations against such individuals. Next para I have already read, para H. At the last hearing, the Honorable Chief Justice of Pakistan highlighted internal pressures within the judiciary, referencing the historical incidents. Past practices such as the appointment of monitoring judges for trials in subordinate judiciaries and the handling of political cases, including the formation of benches for such cases, demonstrate that approaches from the executive and its institutions were not the only concerns. The judiciary itself was implicated in these practices. A firm message must be sent to other state organs, and the judiciary's role in these internal approaches must be addressed. Incidents should be thoroughly investigated, reported, and conclusively resolved to prevent recurrence in the future and to uphold the integrity of the judiciary for generations to come.